All right, court next calls the people of the state of Michigan versus Sarah Elaine Crocker, case number 254143FY. Parents as counsel.
Joanna Carey for the people.
Haven O'Mara on behalf of Mr. Harrison, or on behalf of Mr. Harrison for Ms. Crocker.
Mr. Harrison's in trial today.
Yes.
All right. We are here for a probable cause conference. Does not look like there's a resolution. Is that true?
That's correct.
So we are set for a preliminary examination next week. Are there any issues we need to address?
If I could address bond quickly.
Well, let's address the issue of whether or not we have any discovery issues or witness issues for next week.
We do not yet have the labs that appears. And I'm looking for the true nerve. I think we can get that, but we do not have the labs yet.
But there was a true narc done.
Or to
Both field tests.
field test.
All right. All right, so I'll just mark that you're waiting labs, but there was a field test. Ms. Carey, the request regarding bond, do you have any objection to hearing that today?
We already heard one thing. I don't think that anything's changed. So, I'm not sure when that one is about.
I show it's up the 17th of October.
So
I suppose it wouldn't be an issue to file the motion, file a formal motion, give notice, so I'll withdraw.
Okay. I'll note that you'll file a motion. Anything else?
No, you're.
See everybody next week. These are case numbers, case number 254091FY is the people of the state of Michigan versus Mindy McNamara. Case number 252951OT is the people of the city of Cadillac versus Mindy McNamara. Appearance as counsel.
Joanna Carey for the people.
Haven O'Mara on behalf of Mr. Harrison, felony filed for Ms. McNamara on the misdemeanor.
And just for the record, Mr. Harrison is in trial today, correct?
Yes.
So we are here on a PCC on the felony. And our first pretrial on there?
Yes.
Final pretrial. Final pretrial. Are there any resolutions in either one of these cases?
Not at the moment, Your Honor. I would anticipate either orally hearing a bond motion today for release to treatment or a motion with notice for the prosecutor's office. And we're trying to see if we can get that accomplished before a global resolution in both cases. So we'd ask that the final pretrial be adjourned for misdemeanor, or I'd ask that.
Ms. Carey?
I'm not opposed to adjourning the final pretrial and as far as the final motion or the motion for release of treatment. Really don't have any information for writing so that we can prepare for it.
I got this right now.
Well, I do believe that Ms. Carey has, this jurisdiction for a long time has allowed verbal motions, but Ms. Carey does have the right to have a written motion and have the response time. So the court will expect a written motion on that. In regards to the final pretrial, Ms. O'Mara, because you are not the attorney of record, I will reset this for a final pretrial.
Your Honor, I respect that it's not going to alter anything, but for further request of my client, may I approach and give you the release to treatment information?
You can. Ms. Carey, do you wish to approach as well? And for the record, Ms. O'Mara showed me a letter from the treatment facility indicating that there was a bed available starting yesterday. All right, so we will set the misdemeanor for a new final pretrial. And on the felony case, Ms. Carey, are you aware of any discovery issues?
I'm not.
All right. And there's not a waiver of the 21-day rule, so we will see everybody next week.
Thank you, Your Honor.
Thank you. Ms. McNamara, you can go with the bailiff. For next calls, State of Michigan versus Corrine Lee McDade.
Mr. Hartnell is covering all of them.
All right.
Apologize for the delay, Your Honor.
No, you're fine. I just called it. This is case number 252562FY. Appearances counsel.
Joanna Carey for the people.
Robert Hertel for Ms. McDade.
Yes.
Ms. McDade, I am filling in for Mr. Harrison, who's in trial today.
We are here for a probable cause conference. It does not look like there's a resolution. Is that accurate?
It is, Your Honor.
So that puts us at prelim next week. Ms. Carey, are you aware of any issues for preliminary examination?
I'm not.
Mr. Hartel?
Nor mine, Your Honor.
All right, and there is not a waiver of the 21-day rule, correct?
No.
All right, then we will see everybody next week.
Your Honor. Thank you.
Our next call is the people of the state of Michigan versus Jeremy Dennis Cochran, case number 254141FY. It's no contest.
Oh, I missed that.
Appearances counsel.
Joanna Carey for the people.
Robert Hertel for Mr. Cochran, who joins me to my right. I am filling in for Mr. Harrison, who's in trial today.
Mr. Cochran, are you okay with Mr. Hartel filling in for your attorney today?
Yes, sir.
All right. We are here for a preliminary, probable cause conference. Is there any resolution?
Yes, Your Honor. My client would accept the people's offer of attempted resist obstruct. We would need it to be no contest due to lack of recollection due to intoxication. The police report itself doesn't mention much about the intoxication, but he would testify under oath that he does remember what he consumed and when he blacked out, if the court was going to accept that.
Ms. Carey.
I believe alcohol was involved. No, it's not laid out in these reports, so I'm amenable to that.
All right. Mr. Cochran, have you heard what the attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. It's my understanding that you're going to be pleading no contest to an added count of an attempt to resist and obstruct a police officer. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000. Do you understand that?
Yes, sir.
In exchange for that plea, the people will be dismissing the completed offense of resist and obstruct, which in of itself is a 2-year felony. However, there's a habitual third notice that goes along with that, which would make that 2-year felony a 4-year felony. So you're going to plead to a 1-year misdemeanor in exchange for dismissing a 4-year felony. Is that your understanding?
Yes, sir.
Now, it's also my understanding that you're going to be pleading no contest. No contest allows the court. So basically what no contest means is that for certain reasons, and we'll get to those reasons in a moment, that you accept responsibility without saying that you're guilty. And there's only a few ways that the court can accept those no contest pleas. Now, with a no contest plea, the court will receive a document. And it looks like it's going to be a Wexford County Sheriff's Office report. And I'll be able to review that document to determine whether or not there's a factual basis to find you guilty. And I can use that for sentencing purposes. Do you understand that?
Yes, sir.
Now, your attorneys stated that the reason for the no contest plea is a lack of memory due to intoxication. Is that accurate?
Yes, sir.
So prior to the event on September 21st, what is the last thing you remember?
I had 3 shots of Black Velvet and 2 beers.
What's the next thing you remember? Okay, but at some point, did you get your memory back?
No,
So you have no recollection of what's happened over the last week?
Might be able to follow up, Your Honor. If I recall correctly, you're saying that you don't remember immediately after consuming the alcohol for a period of time, correct, sir?
yeah.
But you still remember earlier today, right?
Oh, yeah.
Okay, so what was the earliest thing you remember after you weren't blacked out anymore? Was it waking up in a certain location, maybe something of that nature?
Yeah. But my friend's house,
Okay, what date and time was that, if you know?
same day. Saturday.
Okay, but, so you do remember waking up at your friend's house and everything since then, but just not that chunk of time before that and after the consumption of the alcohol, correct?
Yeah.
I believe that should be sufficient. If the court.
Ms. Carey?
I'm a little bit confused by that, Your Honor. I don't know if that's sufficient or not, frankly.
I have to agree. I'm not convinced that gets us to a level of intoxication. I arraigned him on the 22nd from the jail. This is alleged to have happened on the 21st. So if what he's saying is accurate, he doesn't remember his arraignment?
Do you remember being arraigned?
Jail.
Do you remember anything before you were arraigned, sir?
Oh, no.
Do you remember the guards walking you down the hall to be arraigned?
Oh, no.
Okay. I don't know if that helps or not.
Well, what it tells the court is that I need to rearraign him because I'm not sure his arraignment was accurate then. If he has no recollection of it, I'm not sure he was sober in order to be arraigned. So what I'm going to do is I'm going to rearraign you on these charges. All right, Mr. Cochran?
Yeah.
Do you understand what I'm saying?
Yeah.
Mr. Cochran, do you have any, how far in your education did you go?
Oh,
12th grade? All right. And you don't have a guardian for you at all, correct? You're able to make your own decisions.
oh, yeah.
You don't have anybody that appointed by the court that does that for you. And how long ago did you graduate?
When I graduated,
Yes,
1990.
1990. All right. And was that from MESIC by chance?
Yeah.
All right. I figured, given the name, that's probably where it was. You have been brought to court on a charge arising on September 21st, 2025 in Springville Township of Wexford County. And in that complaint, it alleges that you committed the offense of police officer assault, resist, or obstruct. In particular, Deputy Kyle Ramirez. That is a 2-year felony, which means you could be put in prison for up to 2 years and or a fine of $2,000. And consecutive sentence may apply if that happened in a place of confinement. Do you understand that? Additionally, the prosecution has charged you as a habitual offender third, which means that you have at least 2 prior either completed or attempted felonies in your past. And in particular, there was a felony on June 6, 97 of larceny in a building, and April 25th of 05 for a police officer assaulting and resisting arrest. Do you understand that?
Yeah.
That habitual third makes that 2-year felony a 4-year felony, and the $2,000 fine a $4,000 fine. Do you understand that?
Yeah.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to have an attorney appointed. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one will be appointed to represent you, but you may be required to repay a portion of that expense. And Mr. Harrison has been appointed to represent you, but Mr. Hartel is substituting for him today. Do you understand all that?
Yes, sir.
So based on what happened before, the court will enter a not guilty plea on the rearrangement. And we will continue down the path. So just let me make a few notes here. Mr. Hartel, based on what we recently discovered and the need to rearrange him, how do you wish to proceed today?
I still would feel comfortable moving forward with the plea and sentence as long as the court and the people are, based on my meeting with him earlier in private. I wasn't aware of his lack of recollection of the arraignments, but I do believe everything else is all the same, Your Honor.
Ms. Carey, do you have any objection to that?
I don't.
So, Mr. Cochran, let me ask you, do you have any other memory issues? I mean, do you normally suffer from memory issues?
I have diabetes and I blacked out. I haven't drank in over 2 years and I had I had a colon cancer. And, I stopped drinking and that's it. I blacked out. The doctor said I blacked out because I have diabetes.
So sometimes you go into like a diabetic coma type
Yeah.
situation? All right. All right, based on what I've heard earlier today in regards to the defendant's memory, I believe there is a justifiable reason to take a no contest plea. I've been provided with what's been marked as what's actually defendant's exhibit number 1, should be plaintiff's exhibit number 1.
I handed it to them. I apologize.
Sorry.
No, that's fine. I just see it's the prosecutor's copy. So I will remove that sticker. I've been provided what's been marked as People's Exhibit number 1, which is a Office of the Sheriff of Wexford County incident report number or case number 83-2501731. Ms. Carey, do you move for its admission?
Yes.
Mr. Hartel?
As do I.
People's 1 is received. Give me a moment to review that. All right, Mr. Cochran, I have a couple more questions for you. Back on September 21st of this year, were you on probation or parole?
Yes, sir.
Were you on bond?
$100 bond.
But in any other case, were you on bond? Now, do you understand that you have the right to have a trial, the right to a jury trial?
Yes, sir.
You have the right to call witnesses and have those witnesses speak for you at trial.
Yes, sir.
You also have the right to cross-examine any witnesses called against you. You also have the right to remain silent and not have that silence used against you, and to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand all those?
Yes, sir.
By entering a no contest plea today, you'll be waiving the right to a trial and you won't have a trial of any kind. Do you understand that?
Yes, sir.
Do you still wish to waive your right to a trial?
Yes, sir.
Then to the allegation that on or about September 21st, so, sorry. Other than the plea agreement, has anybody promised you anything?
Yes, sir.
Has anybody threatened you in any way?
Yes, sir.
And is your own free choice to plead today?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
I'm not.
No, you are.
Now, Mr. Cochran, to the allegation that on or about September 21st, 2025 in Springville Township of Wexford County, how do you plead to added count 2 of an attempt to resist and obstruct a police officer? I anticipate it would be no contest. How do you plead?
Guilty. No contest.
All right. The counsel, I have reviewed People's Exhibit number 1. Do you believe it provides a factual basis in which to accept the plea and the court rules have been complied with?
Yeah.
As do I.
As does the court. I find the plea is knowing, voluntary, and accurate. Mr. Cochran, I find you guilty of an attempt to resist and obstruct a police officer pursuant to the plea agreement. The completed offense and the habitual third offender notice will be dismissed at the time of sentence. In particular, I find that on September 21st of this year at approximately 2:31 in the morning, law enforcement was called to a residence in Springville Township for an assault. Upon arriving, law enforcement discovered Mr. Cochran outside. He was during some communication, he hit a police car. He refused to comply with commands. He went dead weight, pulling away. He had to be physically removed from the patrol car when the time came. Again, going dead weight. So I do find that he resisted police officers. I also find that the commands given were lawful, given the situation. Ms. Carey, are we able to plead today?
Sentence, yes.
Sentence, I'm sorry. Mr. Hartel, any allocution?
Yes, Your Honor. I would ask the court to factor in all the things, not only in the report, but what my client has also said. I'm not trying to making excuses, obviously. I do believe he is repentive of what happened. I know I went through the report with him personally. He definitely expressed a desire those things had not occurred. He did mention both to myself and to the defendant in court a moment ago how he believes, and I'm paraphrasing a bit, but how he believes his tolerance was lower due to the fact that it'd been quite some time since he consumed alcohol. I'm not a medical expert, but it sounds like things inside of him were in a different position than they used to be that might have affected absorption levels. I'm not sure. But he does know that even a small amount of alcohol in his present state will have negative effects. He has every desire to avoid being in the situation again. I did advise him that yes, in theory, the court could make this just fines and costs, or the court could do jail, or the court could do probation. He advised me that if the court felt the need to choose between jail or probation, that he would believe that he would do well on probation. And I believe him when he tells me that, not only because he has no desire to drink to avoid this scenario reoccurring, but he's also highly motivated to keep his job. He does have, I believe, a few more months in a seasonal employment, as many people in the local area working in the Christmas tree industry, as I know many people have over the years. And I do believe that if the court did decide to supervise him, we would not see him here for any issues with that. I would ask the court to factor that in when fashioning a sentence. I don't doubt Ms. Carey has things there.
Thank you. Ms. Carey?
If you people are gonna ask for a period of probation, I think his level of intoxication, I think was significant, and it's not his first alcohol related offense. He had a disorderly person drunk in 2022. And then it had been a while, but he also had resisting and obstructing in 2005. He had larceny in a building that looks like in 1997, and a drunk driving in 1996. So alcohol is not new to him. I questioned him how long he had not been drinking. And it sounds like, according to the report, he gets pretty out of control when he is drinking. Therefore, I think a period of supervision is appropriate.
Thank you. Mr. Cochran, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Sir, I just feel bad when I did it. I was going through a lot through a couple of years. Like I said, I had cancer. I don't blame anybody else but myself for drinking. But, you know, I really apologize for this society.
So in 94, you had a disorderly person. 96, you had an operating while intoxicated. 98, an operating while intoxicated second. Did you stop drinking after any of those?
Yes, sir. I went to AA meetings. I was sober for a couple of years. I went to year 2000. I went to Harbor Hall for 3 months.
Your resist and obstruct that you had in 05, was alcohol related to that at all?
B&E.
No, it's charged as a resist and obstruct to law enforcement.
I couldn't.
You don't remember that? And then you're in 22 had a disorderly drunk. So did you stop drinking after the case in 22?
Yes, sir.
For how long?
I think I was going to AA meeting at a couple of years.
Couple years. And so what was going on this day that you, I mean, I know you said you've been through a lot, but what happened this day?
Mental issue. About 5 or 6 months ago, I was in Florida. I was in mental institution twice.
Okay. Are you working mental services now that you're back here?
No.
All right. Anything else you'd like me to know? All right. Well, I do believe a period of probation is appropriate in this case. Well, you have somewhat of a past. It looks like the majority of it is probably alcohol related. You've had periods of sobriety in your past, so I think it's going to be beneficial to put you on probation to help get you back in check with that sobriety. Now, I know you haven't been on bond very long, about a week. I don't have any bond violations, but I didn't order you to stop drinking. Did you stop drinking during that time?
Yes, I don't have desire to drink. I know what my side effects are. I'm done.
All right. I'm going to put you on a period of probation for 12 months. During that period of time, you're not to violate any law. You're to report as ordered, keep your contact information current, and not leave the state without permission. You are eligible for early release. So at the 6-month mark, if you've done everything we've asked you to do and you've been successful, you can be released from probation. If your probation officer doesn't think that you should be, but you think you should, you can petition the court on your own and we'll have a hearing and I'll make that determination. During the period of time that you're on probation, you are not to consume any alcohol and you'll be subject to testing pursuant to the terms of your probation officer. I'm not going to order you into a recovery program, but I suggest that you might want to take advantage of those. Again, you said you worked AA in the past. I'm also going to order any counseling that your probation officer feels as though appropriate. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $150 fine, $150 court costs, $150 attorney fee. I'm going to charge 6 months of probation. That's $180. If you end up staying longer than that, you'll be required to pay the monthly probation fee. There's also 1 day jail with 1 day credit. Now, Mr. Cochran, I know you know this, and you don't need me to say it, but I'm going to say it anyways. You lucked out. You could be looking at a pretty hefty felony in your past, on your record. And so I want you to seriously look at the benefit that you've been given and do some thinking on your relationship with alcohol, all right? Now, because I have sentenced you to a term of incarceration, even though it's time served, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. All right. I am going to add one more condition, and that is that you not act in any violent, threatening, or intimidating behavior. All right. You can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan, and then go downstairs and get signed up for probation.
Thank you.
All right. Your exhibit, Ms. Carey.
It's your text. And it's under there, but it's decision deferred.
All right. Court next calls the people of the state of Michigan versus Grant Edward Lee Bailey, case number 254100FY. Appearances counsel.
Robert Hartzell for Mr. Bailey, who just need to let you keep track there for a minute. I am filling in for Mr. Harrison, Mr. Trout, with court order.
Right, and we are here for a pause conference. Also, did we process that request yet, Danny?
I have not.
All right. The court had also received a request for a show cause for a probation violation, bond violation, in that the defendant did not sign up for testing. We had him go down to test this morning, and on a 14 panel, he tested negative. Mr. Bailey, have you signed up for testing now?
Testing, I was told that I just show up. I went down after my last court date I had, and I signed up and everything. The reason why I couldn't show up Monday is I didn't fully understand. I thought I did.
Okay.
So,
But you understand how the process works now?
yes, I do.
All right. We are here for a probable cause conference. Does not look like there's a resolution. Is that accurate?
There is no resolution at this time, no, Your Honor.
Mr. Bailey, it also looks like you've not gotten your fingerprints taken.
No, I had that set up for today, and then I was looking at my paperwork and I realized I had this,
Okay.
so I showed up to this.
You're gonna need to have that done before we're in here again next, all right? Ms. Carey, so it looks like we'll be set for preliminary examination next week. Is there any issues that you're aware of?
No, we do have the results.
All right. Mr. Hartel, are you aware of any other issues?
I am not, Your Honor.
All right. Some notes here. All right, we will see everybody next week for prelim then. Mr. Bailey, just a reminder that your bond conditions continue, all right?
All right.
We'll do that at a later date because the show cause hasn't been, I authorized it, but it hasn't been done yet, so.
Understood. Thank you, Your Honor. I'll check.
Our next call is the people of the state of Michigan versus Larry Allen Mitchell.
Yeah, we stop it. That's a good point. Of course, where we are expecting a substitution, we have two attorneys up here as a result. Your Honor.
All right.
Yeah, you take a seat, we'll put him over there. Wherever he's want to. You get double advantage today.
This is case number 254099 Y. Francis Counsel.
Robert Hartel filling in for Mr. Harrison. We are expecting a substitution of counsel as well, who is sitting next to you, Your Honor.
Mr. Fraggle.
That's correct, Your Honor. I'm sorry for the late substitution. I think there's some confusion on Mr. Durham-Murphy's part. Yesterday, we found out he would not be able to be here. So I decided to step in, assuming that it would have been adjourned, and we'll take it forward from here.
All right. Mr. Mitchell also has a probation violation coming up, I believe, on the 7th. Are you plan on coming in on that case as well? All right. And just for the record, that's 25782 SM. Ms. Carey, any objection to adjourning today's PCC? All right. We will adjourn to a new PCC date.
Here, Robbie or Mr. Frank.
And we'll be there.
Do we have the substitution paperwork today?
I just have I will have it in later this
Okay.
afternoon. I have to sign the substitution consent right now.
All right. Mr. Hartel, you said this is Mr. Harrison's?
Yes, for a few minutes anyways, Your Honor.
No, I get that, but he's the one assigned to it, right?
Yes, sir.
So
Yes, you said so.
And I know he's in trial for the next couple of days, so if there's a delay, I understand that, but I've at least made notes. So, Mr. Fraggle, we'll expect you on both cases.
Okay, thank you.
All right, thank you.